Thank you very much, Mr. Chairman, and thanks to each of the witnesses for being here today. We've had this conversation many times. I am one of the people here on the committee who used to practice law as well. I represented franchisees in disputes with franchisors, and I certainly know and appreciate the franchise model and the opportunities that it creates. Before that, though, before law school, I worked in my mom's small business, and I look at the title of this Save Local Business Act, and we all want local businesses to thrive and succeed. This bill is not the way to do it. And as we've heard multiple times, this BFI case that we've talked about so much does not upend the franchise model. And as we've heard again this morning, that was made clear in the Freshie case. A franchisor is not a joint employer if they act like a franchisor by protecting brand standards. And yes, a franchisor can provide guidance, and there was an advice memo from the NLRB on that. Employee handbooks, payroll services, those things, as long as they're optional, do not make a franchisor a joint employer. And that if they're going to act like a joint employer, they should be treated as a joint employer. And Mr. Rubin, you've talked a little bit about why a fact-specific standard is important, and I really appreciated also your response to Ranking Member Scott's question, because as I read this language with the and, all of those have to be met to be a joint employer. Why is it important that there be a fact-specific standard when it's assessing joint employment?
Under any standard, the current standard under the FLSA, the NLRA, state law, other federal statutes, it all depends on the actual relationship between the parties. There are so many ways franchisors, franchisees, lead companies, supplier companies can structure their relationship. That's a good thing. We welcome flexibility in how companies operate and how they interact with each other.
And those are typically spelled out in the franchise agreement, correct?
Yes, and it's set forth in as clear language as they can set it forth, and the courts must look at the specific factors and see what happens both as a matter of contract and then on the ground in terms of the actual exercise of control. That's why it's fact-specific. You can't just say because you have a relationship of user, supplier, or franchisor or franchisee, you are or are not a joint employer. You have to look at the facts on the ground and the legal relationship by contract under the law in the jurisdiction under the particular statute. That's how you analyze cases.
I certainly agree that the language in this bill would make it much more confusing and create much more uncertainty about who is a joint employer, what entity is a joint employer. And Mr. Rubin, we're sitting here in 2017 and there's still a pay gap between women and men. It's difficult for individuals to prevail in Equal Pay Act claims. Congress did pass the Lilly Ledbetter Fair Pay Act in 2009. There's also the Paycheck Fairness Act, which I support, that would further strengthen the right of pay equity. If this bill, the Save Local Businesses Act, were to pass, would it make it more difficult for a worker to succeed in an Equal Pay Act claim? If so, how?
It probably would. That's another great uncertainty with the way this bill is written. The Equal Pay Act is incorporated into the FLSA. Right. As a result, it adopts the standards set forth in the FLSA. It depends on Congress's intent at the time, and that's why there's going to be litigation over it. But certainly, if this bill changes the definition from what it's been going back to the early 30s to what is proposed here, it will affect the Equal Pay Act, make it far more difficult, in fact, I think impossible, to prove joint employer relationships. Same thing will happen under the Family Medical Leave Act, and certainly under the Migrant and Seasonal Agricultural Worker Protection Act, which also bars the FLSA definitions. So we are going to have an explosion of litigation, more uncertainty, more expense for franchisors, franchisees, contractors, and the like if this bill were enacted.
And I know it's been asked before, but just to clarify, how many cases are you aware of where a franchisor has been found to be a joint employer with its franchisees under the Fair Labor Standards Act?
0.
Thank you. I yield back the balance of my time.
No one yields.